to hear proceedings and the circumstances in which they will recognise that the foreign court had jurisdiction, a jurisdiction that they will recognise for enforcement purposes. And then there are a series of other defences to recognition, which are to a greater or lesser extent comparable to those that exist under the Brussels regime, with some differences. So we have specific recognition that proceedings won't be, a judgment won't be enforced if it's brought contrary to a jurisdiction or arbitration agreement. And that's in statutory form. CJJA is the Civil Jurisdiction and Judgments Act. Sorry, that should be 1982, not 1992. So a judgment won't be recognised if the foreign court acted in breach of a jurisdiction or arbitration agreement. Won't be recognised if it's obtained by fraud. So that's a similar situation as under the Brussels Convention. Obviously, there may well be differences, or are likely to be differences as to the way that the law operates in practice, but there are similar ideas here. Public policy as defence, inconsistency with a prior judgment. So the idea of irreconcilable judgments also appears in relation to the common law rules. Lack of natural justice, that's interpreted in quite a broad way. And there's a specific rule for if the judgment is for multiple damages, which was introduced in the 1980s, as I've said, particularly to deal with the fact that the United States had introduced triple damages awards in antitrust cases, and it was intended specifically to combat that. I've put a few case names in here really just to highlight the fact that these provisions are based on case law rather than any code or legislation for the most part. You can see a couple of examples of references to legislation, but a lot of the law in this area is case-based. So if we look then at the approach of the English courts to jurisdiction, we can distinguish between judgments in personam and judgments in rem, and I'll mainly talk about judgments in personam. So judgments in personam would be concerned with determining rights against a person, so rights and claims between people, as distinct from rights in property that can be asserted as against the world. So judgments in personam will be recognised if the jurisdiction of the foreign court was based on essentially either presence or submission to the jurisdiction. The English rules, traditionally, although not necessarily in practice because of the form of convenience requirement, the English rules would allow for jurisdiction to be based on presence of somebody within the jurisdiction at the time that the proceedings were commenced, or when the writ was served on the person who was to be subject to proceedings. That was the traditional approach. So under the rules for recognition and enforcement of judgments, it's clear that residence within the state of origin when the proceedings were commenced is sufficient. Mere presence has been relied on in the past, but it's doubtful as to whether it would be satisfactory these days. In fact, highly unlikely, I would think, that it would be satisfactory these days. There's a complex case law relating to companies, obviously. So Adams and Cape Industries from 1990, it was a substantial case which discussed the case law relating to the ways in which a company could be seen as being present in a jurisdiction through its business activities. It might have a place of business within the state of origin, but it could be present through activities which did not involve some kind of fixed establishment within the state of origin if there was sufficient evidence of the business activity within the jurisdiction, not just directed towards that jurisdiction. And in terms of submission to the jurisdiction, so submission to the proceedings in the state of origin, then it's clear that a party would have submitted if they were the claimant, or if they made a counterclaim. They may have submitted a defence on the merits of the claim, or there may be a prior jurisdiction agreement. And then in the past, there were various debates about whether somebody had submitted to the jurisdiction if they had merely appeared to contest the jurisdiction. And this was established, or this was dealt with by statute, again, the Civil Jurisdiction and Judgments Act in 1982. And these are, I think, sort of familiar ideas, again, from the Brussels regulations as to when somebody is taken to have submitted to the jurisdiction. So the same kind of issues and problems evolved in the purely English law as have been discussed under the Brussels regime in the sort of late 20th century, the last couple of decades of the 20th century. So presence and submission as such, although there is an extensive case law and it's reasonably clear what the rules are, even though they are case-based, it provides quite a narrow basis for recognising the jurisdiction of the foreign court. And it's seen as anachronistic and out of date, but there hasn't been any concerted attempt to change things. It's seen as being something which has historically developed and is a survival of like old-fashioned ideas rather than being a conscious choice. So depending on what happens with the Lugano Convention in particular, then there may be an incentive for the UK to develop its rules on jurisdiction in this area to form a more consistent modern approach. I should say that very much the emphasis of litigation in the UK, as has already been mentioned in other jurisdictions, is on the assertion of jurisdiction in the first place rather than the recognition and enforcement of judgments. We really have relatively little case law, little litigation on enforcement. Generally, there's much less litigation about enforcement than in most EU member states. So it's not surprising that the law in this area is relatively poorly developed. The emphasis in the UK has tended to be on the large commercial cases where there is a lot of emphasis placed on asserting jurisdiction in the first place and disputing jurisdiction. And then after that, the case settles, and so there is no particular demand for rules on recognition and enforcement. And I think being an island is perhaps part of the explanation for that small cross-border trade cases are less likely to exist, and so disputes relating to smaller cases and enforcement across the border is more limited. So judgments in rem, so typically judgments concerning land or intellectual property, or in admiralty cases, the seizure and sale of ships, then jurisdiction is based on the situs of the property. So then there are two statutory regimes, one under the Administration of Justice Act 1920, the second is a very similar but slightly more modern and updated approach under the 1933 Act. The important aspect of these regimes is really the fact that they introduce easier procedures for recognition and enforcement. So they introduce a registration scheme, whereas under the common law it's necessary to start new proceedings. So a new action isn't required. They do differ in some minor respects from the common law regime, but essentially their approach to the jurisdiction of the foreign court and the defences is very similar. So it's not worth going into the details, or it's not possible to go into any details here. So they're not exactly the same as the common law rules, but the differences are really quite minor. So one of the questions that's been raised here is to what extent this regime might be applicable in relation to some EU member states. There were a certain number of EU member states who were fell under these schemes before the Brussels Convention became into force in the UK, which was in 1987. And so the statutory regimes are based on bilateral conventions between the UK and other countries. It's the existence of the bilateral convention which enables them to be brought within these statutes. And one of the questions is whether the pre-existing bilateral conventions although superseded by the Brussels Convention, can continue to exist and could be revived post-Brexit. And so I've listed a number of countries with whom bilateral conventions exist, and it's been suggested that there might be a possibility of relying on those, although that's likely to give rise to litigation as to whether such reliance is possible or not. The UK acceded to the Hague Convention on Choice of Court Agreements, along with the EU's accession to that convention in 2015. So it acceded in its own right to the convention in last year. So this is potentially quite an important assistance to recognition and enforcement, given the importance of choice of court agreements within international litigation. And a benefit of that is that it involves registration rather than starting new proceedings. And so the procedure for registration, or the reference to registration, is provided again by the Civil Jurisdiction and Judgments Act 1982. The UK considers itself to be a contracting state to the Hague Convention without a break, because it's deposed the instrument of accession with a view to it continuing to, when it left the European Union, continuing to be a party to that convention without any gap between its membership between its status as a contracting state as an EU member state and its independent status. And the convention is implemented, as you see, by the Private International Implementation of Agreements Act 2020. So we've got those three possibilities: the common law rules, which are really rather unwieldy and unsatisfactory and expensive; the statutory regime, which may or may not apply to member states, but which relies on essentially the same rules as the common law system; the convention, the Hague Convention, which applies where there's a jurisdiction agreement; and then there's the possibility of accession to the Lugano Convention by the UK in its own right. And I think this was has been a major hope for the UK. So it needs to have the unanimous consent of all current contracting parties in order to accede to the convention, as specified in Article 70 to 72 of the convention. And quite early on, formal consent was given by the non-EU contracting parties to the Lugano Convention, Iceland, Norway, and Switzerland. The EU has been thinking about this for a long time. So the UK deposited its application on the 8th of April 2020. Under the convention, ideally, or the efforts should be made to make a decision on this within a year, but that wasn't possible. So in April 2021, the Commission indicated that it thought that accession wasn't possible, and formally then in the 4th of May, it issued a communication to the European Parliament that the EU, giving its assessment that the EU should not consent to the accession of the UK to the Lugano Convention. And its rationale for that is that it considers the Lugano Convention to be part of the common justice area. And as you can see, I've highlighted in red on the slide, it's seen as a flanking measure for the EU's economic relations with the EFTA EEA countries. Of course, an alternative argument is to say that it should be open to third countries, and that it's not something which is purely limited to EFTA EEA countries. So there's certainly scope for disagreement on that. The European Commission then again formally in June 2021 deposited a note verbal with the Swiss Federal Department of Foreign Affairs, saying the EU is not in a position to give its consent. So the matter is now waiting to see what the Council of the EU has to say. I believe the next meeting of the Justice and Home Affairs Council is in October, and it would make a decision on this for which it needs a qualified majority. So we wait to see whether there's a possibility of accession to the Lugano Convention. The things that I've read suggest that it's not very optimistic, but I don't know. There's certainly plenty of NGOs and other organizations who are arguing strongly that it should be possible. So I hope that's a useful overview of the current situation for the UK. Not a particularly promising outlook just at the moment, but no doubt things will eventually improve. Thank you very much.